outside the United States, state of Tennessee, and this honorable court.
I believe somebody oiled the chair and it got on it. Good morning. Before we call the first case, a reminder that the cases are being live streamed. Our oral arguments are being live streamed. So if your case, and I don't know if there is one this morning or not, that involves a minor, just kind of keep that in mind, and to the extent you can, avoid using the minor's name or anything identifying. We want the courts to be open to the public, and they are, but we also see no need to necessarily put a child's name out on the internet in an unfortunate, perhaps might be an unfortunate light. Call the first case, please.
Corey Delaney versus Amy Chico.
Good morning, Your Honors.
Good morning.
May it please the Court, my name is Joshua Hedrick on behalf of the appellant, Amy Chico. The judgment of the trial court in this case should be reversed for two reasons. The grant of the order of protection was inappropriate in a case where the only act proved to have been done is more than a year old. And second, because the doctrine of laches should apply to bar such a claim. The case at bar is a relatively simple one. We had two people who were in a domestic relationship. On March 5th of 2020, the appellant, Ms. Chico, was alleged to have pushed the appellee and to have hit her. In the year and a half that followed, there were no more allegations of violence per the proof at the hearing. The parties lived together during that year and a half time, and during that year and a half time, the appellee wrote a letter, a card, praising Ms. Chico for how far she had come and how much progress she had made in improving herself. The petition for the order of protection was filed on November 12, 2021. I'm calling it a year and a half. That's an approximation. I think that it's good enough for our purposes. Our position is that this act is too old to support the grant of an order of protection. That after a year and a half, it should not be enough to say, I am in need of injunctive relief at this point. Now, we know the statute 363605 allows for the issuance of an ex parte order on good cause. The statute then goes on to cite how a hearing would result in a final order of protection. We took the position at the trial court that good cause must be required for the final order to issue, although the statute does not again say good cause in talking about the final order. There must be some basis, there must be some requirement beyond just asking for an order of protection. And we took the position that because the ex parte order and the final order deal with the same allegations in the same parties, that it should be some similarity of quantum of proof. When we think about what this request is of the court, and one of the things that I think about when I'm preparing, I'm not before this court very often, unfortunately. I'm typically in front of the Court of Criminal Appeals. And when I get ready for argument, I try to think to myself, well, what will they ask me? What will they want to know? And in getting ready for this argument, my thoughts were that the court's probably going to say, all right, Mr. Hedrick, then what is the time limit, right? If you're unhappy with the year and a half, where shall we put it? And I will tell the court that I don't want to be beyond my station, but I think that we can take from our statutory scheme relating to these that at least a year is too long. And I say that because the order of protection is issued for a year. It has a year as its natural duration. We know that an order of protection, if it's violated, the final order, is extended for a year. And we know that these acts, which are complained of, the pushing and the hitting, would be a misdemeanor if criminally charged, and misdemeanors have a 1-year statute of limitations. So again and again, we see the legislature limiting this action with a year limitation. And I think that we have some...
Well, I mean, it would be out, it would probably be, assuming that 1-year order protection was entered, it would be out for longer than a year from the event itself.
I agree with that, Judge, that if the event happened, I think if I understand you correctly, if the event happened January 1st and the petition was filed on the 10th of January, then it would actually be a year plus that time. And I do agree with
Counsel,
that.
let me ask you this.
Yes, sir.
The order of protection is to prevent any acts of violence toward the person, right?
Yes, I agree with that.
It's not to punish for an act of violence that has been committed.
I agree. Right? I do agree with that.
And it's based upon the fear in the person's mind that an act of violence may be imminent if they are not protected from that act of violence. Is that correct?
I do agree with that, Your Honor, although I would...
Why a prior act of acting out or violence or any act against that person, why that cannot be used to show a prior disposition in the party who is being ordered not to come around the other party? Why is that?
So I'd like to answer that in two different directions, Your Honor. And the first direction is in terms of evaluating the proof with respect to the testimony that the appellee is in fear. And so I want to be very careful how I present this argument, because I'm not trying to engage in victim blaming, but I am taking the position that if there is an incident and after that incident, a year and a half passes, during which time there is no problem and no complaint, right? No further concern, in fact, quite the opposite, where the other party is saying, you've changed so much, you've come so far, I'm so happy with your progress. That the fear is no longer reasonable when they come into court and say, I am afraid, that we question the reasonability of that fear, we question the veracity of that fear, given that year period where there is no difficulty, where there's nothing but good things.
But isn't that based upon some act that is about to occur? Maybe that party is about to separate from that party, and they feel that that will be an inciting factor to this party.
So that's what the court found in this case, and the trial court in its ruling said essentially they're breaking up, they're unwinding their relationship. I think it's necessary for there to be some protective order. Our position on that is that that's not the same as proof that there is an imminent risk of violence, or that there's an immediate problem. That injunctive relief requires some sort of immediate harm that is likely to happen. That we don't issue injunctions simply because someone says, I am worried. That there has to be some evidence or proof that there is an immediate risk being presented to this person. And so when we look at someone who has, if we were to analogize it, say, to someone who there's been a year gone, someone said, I would like to cut this tree down, and the neighbor says, you can't, it's my tree. And then a year and a half goes by, and the neighbor goes to Chancery Court and says, I want an injunction against cutting this tree down because my neighbor intends to cut it down. Right? And the court finds, well, he did say a year and a half ago that he wanted it cut down, but then nothing ever happened. We would say that injunction is inappropriate because there's no indication that it's actually going to happen. Now, that's a factual finding question, right? And so when I talk about addressing your question in two angles, that's the first question, is whether the trial court's findings were correct. The second question is one of, should the order of protection be available to someone after that period of time, which is really a laches sort of argument. That not questioning whether the act happened, We're not disputing that there was a pushing, not disputing that there was a hitting, and not disputing that at the time that was disturbing and created fear. But that to delay for a year and a half is impermissible under laches. That it's impermissible under our law to sleep on your rights for a year and a half and then come to court.
Mr. Hedrick, did anything happen between the event and then a year and a half later she goes to seek an order of protection? No, there was no physical violence, correct?
That's right.
Were there any verbal threats or anything like that?
So it's a bit unclear, and the reason I say that is there was no proof of any verbal threats.
Okay.
There's no proof of any threats or physical violence. In fact, at one point, the appellee interrupted the testimony of another witness to clarify that there was no physical violence after that point. The appellee testified that there was what she termed emotional abuse. But it was not developed. Right. It was not cleared up what that meant and whether what she was categorizing as emotional abuse would have been covered under the statute.
So is it fair to say that the triggering of, like, I'm trying to figure out why she came a year and a half later to get it, and was it simply because of they were breaking up, and was that the only expression of the reason why she went to get one a year and a half later? To the best of my understanding from the proof, yes. Okay. I can't say that the record really answers your question very well, okay, other than we can presume that. You know, as a trial lawyer, there's some questions you don't want to. There's some questions you don't ask, and it didn't come out. Okay. It didn't come out at the hearing. Why now? Other than that there was not, I could tell the court that on this record the why now is not some recent violence or threat or incident. So when we're talking about this defense, the trial court doesn't make findings of fact or conclusions of law about whether this is, whether the appellee should be permitted to sleep on her rights for this length of time and then come into court and raise this issue. The claim was raised, the defense was raised in the middle of the case. The court reserved ruling, but then did not return to make findings of fact or conclusions of law. And so I think that that puts us in a position of de novo review. And I think that when we review this record and this record and this case, I want to be clear that what the appellee related in her testimony was unfortunate and inappropriate, and I don't condone it, not even a little bit. However, from the standpoint of the court system's involvement, there must be a point at which we limit the court system's involvement in all matters. And we are past that point in this case. If there had been some proof of an ongoing problem, an ongoing threat, or even if there had been some proof that there was some act done by the appellant that caused the delay, that the appellant prevented her from going to the courthouse and filing, or the appellant threatened her or said, if you file an order of protection, then I'll do something bad to you, and as a result, she never went, I think we would have a different result. But on these facts, there just is no explanation, and without an explanation, it should not be permitted.
Are there any secondary effects or impact on your client because of the issuance or the existence of the order of protection?
There's a great deal, Your Honor, and I'll cite, although it is not in the record, the record does not specifically relate that, but in the case of Kite, that's 22 Southwest 3rd, 803, our Supreme Court makes observation of some of the secondary effects. We're all well aware, and I think the court could take judicial notice of the impact on your firearms rights from a federal standpoint, but there are clear impacts on employment. We know from this case, from the record in this case, we know that the parties were both employed by Boys and Girls Club of, I'm going to say this wrong, Boys and Girls Club of East Tennessee, or Knoxville, the Knoxville Boys and Girls Club. We know that there are difficulties getting housing or jobs or anybody that does a background check, which is really everybody.
And when I say that, I recognize that I'm outside the record, but I think that the court can take judicial notice that these appear on a background check, and the Supreme Court in Kite specifically mentions that the orders of protection have a severe impact on a person's rights. So, if there are no other questions, I thank you for your time and your attention. Thank you, Your Honor.
Counsel, we appreciate your argument this morning.
Sir.
Call the next case, please.
Larry Mark Mangum versus Lanny Celeste Mangum.